Welcome to another deep dive. Today we're going to be tackling insolvency law in South Africa.
Okay.
This is a pretty dense area of law,
Yeah.
but I think it's super fascinating, and we're going to try to make it fun.
Mm-hmm.
So we have some excerpts from a textbook that we're going to be drawing on today.
Yes, this is a very interesting textbook, actually, because it's dedicated to Professor Robert Sherrick, who's a real leading scholar in this field.
Oh, cool.
So, yeah, we've got some good material to work with.
Yeah, so it's kind of like we have the professor right here with us, guiding our deep dive.
Mm-hmm.
All right, so let's start with the basics. What exactly is insolvency law?
So, insolvency law basically deals with the situation where a person can't pay their debts.
Okay.
So, essentially, it's a system for balancing the interests of the debtor.
The person who owes the money.
Exactly, and the creditors who are owed the money.
Right.
And insolvency law in South Africa really pivots on the concept of sequestration.
Sequestration. What does that mean?
Think of it like hitting the reset button on a person's financial life.
Okay.
So essentially, all of their assets are collected and managed by a trustee,
Okay.
and the trustee then divides the assets between the creditors.
Oh, so the creditors don't get to, like, pick and choose what they want.
No.
Interesting.
Yeah, it's a very specific process with serious consequences.
Yeah, more serious than just like a normal court judgment or something.
Yes, very much so. And the Naidu v. Absa Bank case actually illustrates that. It shows that a sequestration order is not just an ordinary judgment. There's a whole process that gets triggered.
So it's like restructuring their whole financial situation, not just
Exactly.
collecting on a debt.
Yes.
Okay, cool. So who or what can be sequestrated under South African law?
So the Act speaks about the sequestration of the estate of a debtor.
Estate?
Yeah.
Like a house and land?
Not necessarily. An estate refers to the sum total of a person's assets and liabilities.
So like everything they own
Everything they own.
and everything they owe.
Yeah, from houses and cars to rights to payment. And it's not limited to individuals. Partnerships can be sequestrated, deceased estates, and even people who can't manage their own affairs.
So you could have like more debt than assets and still have an estate that could be sequestrated.
That's right. And the case of Miller v. Jenks highlights this.
Okay.
In this case, a gambler had gambled away all of his money and only had liabilities. And the court held that even though at that point he had no assets,
Right.
he still had an estate for the purposes of sequestration.
Oh, wow.
So it's not just the actual assets, it's also the potential for future assets.
Wow, that's really interesting. Okay. So let's switch gears a little bit and talk about like jurisdiction.
Okay.
Like which court actually gets to decide on these insolvency matters?
Sure. So generally, the court where a person is domiciled or resides would have jurisdiction.
Okay, that makes sense.
However, the court might find that it's more convenient for another court in South Africa to exercise jurisdiction.
So they can like transfer the case.
Exactly. And Mulder in another v. Beacon Island Share Block Ltd. shows that the transferee court doesn't even need to have original jurisdiction.
Interesting. So another important thing is this right of review.
Yeah.
So like if a decision is made by the master of the high court, people can like appeal that decision.
Absolutely. So decisions made by the master can be reviewed by a court.
Okay, and then we have this phrase that comes up, formal defect.
Right.
What does that actually mean?
So a formal defect is essentially a procedural error.
Okay.
So it could be missing a deadline, it could be failing to file the right documents, and so the court would then need to determine whether this formal defect actually prejudiced any creditors or affected their rights.
Okay, so it's not like an automatic, oh, you missed the deadline, so your case is thrown out.
No, not at all.
It's about whether it actually like harmed anyone.
Exactly.
Interesting.
And the courts have really wrestled with this concept.
Okay.
The case of Ex parte Slabbert, for instance, the court defined a formal defect as a simple departure from the prescribed procedure. And then you have a case like Swart v. Starbuck and others where the Constitutional Court actually applied a section of the Insolvency Act dealing with formal defects without even saying what a formal defect is.
Oh, wow. Okay.
Yeah, so it shows how this area of law is constantly being interpreted and refined.
Okay, well, that's pretty fascinating. Speaking of like history and things changing, let's talk about the history of South African insolvency law. Like, where did this all begin?
So our insolvency law actually stems from Roman Dutch law, which came to South Africa along with the Dutch settlers.
Oh, wow.
Back in the 17th century.
Okay.
And over time, there were various laws and ordinances that shaped the South African insolvency law system.
Okay.
For instance, in 1803, the Desolate Boedelkamer was established
What?
to administer abandoned estates.
The what? What was that called?
The Desolate Boedelkamer.
Wow. Okay.
This was eventually abolished and replaced with a system of sequestrators. And then Ordinance 64 of 1829 came into play, which sought to introduce further administration for the estates of insolvent persons.
Okay.
Then came a very pivotal moment, 1843. Ordinance 6 of 1843 was passed,
Okay.
which consolidated all existing laws and abolished cessio bonorum.
Say that 5 times fast.
I know, right?
Cessio bonorum. What is that?
So cessio bonorum was a process that allowed a debtor to voluntarily surrender all of his assets to his creditors.
Okay.
But when that was abolished, it really shifted the power away from the debtor to the creditors.
Okay, so the creditors had much more control after that point.
Exactly. And this is really what shaped our current insolvency landscape.
Yeah, so that history is really important to understanding where we are now.
Mm-hmm.
Okay, cool. So let's bring it up to the present.
All right.
What are some of the challenges facing South African insolvency law in like this digital age?
Well, one of the major challenges is in terms of the traditional requirements for notifications and publications. Using physical mail and the government gazette
Yep.
to give notice to people.
Yeah, who even reads the government gazette?
Exactly. And this raises issues of fairness and transparency.
Right.
A case in point is the Sustaining the Wild Coast NPC and Others, a V Minister of Mineral Resources and Energy and Others case. The court recommended using Isixhosa language newspapers and radio stations to reach communities in the Eastern Cape.
Okay.
Because that would be a more effective way to reach them.
Right.
So it highlights the need for, more accessible forms of notice.
Yeah, in a way that actually reaches people.
Exactly. And even the government printing works, who are tasked with publishing the government gazette, have faced challenges in, publishing regularly and on time.
Okay.
The South African Restructuring and Insolvency Practitioners Association, SARPA, actually had to take the government printing works to court.
Wow.
To force them to publish regularly.
Jeez.
Yeah. So, even those tasked with those traditional means of communication are battling to keep up.
It's true. It's interesting to think that even like essential government functions need to adapt to this digital age.
Yeah.
So what about, bringing in the private sector? Do you think they could play a role in modernizing these processes?
That's a very interesting thought. I mean, it would definitely raise questions about oversight and accountability.
Yeah.
But, as the legal landscape is constantly evolving, that's something that can be looked into.
Yeah. Okay, cool. Well, let's move on to a specific type of insolvency. Voluntary surrender.
Okay.
So what does it actually mean for a debtor to voluntarily surrender their estate?
So essentially, it's a strategic decision that the debtor makes to have their estate sequestrated rather than opposing a sequestration application.
Right.
But there are certain requirements. So firstly, the debtor must prove that they are actually insolvent.
Okay, so more debt than assets.
Correct. So their liabilities exceed their assets.
Okay.
Secondly, the debtor must demonstrate that their estate has sufficient free residue.
Free residue, what's that?
So free residue refers to any assets that are not subject to any special rights.
Okay.
In other words, assets that are not already pledged to secured creditors.
Got it.
And that free residue needs to be enough to cover the costs of the sequestration.
So like administration costs and things like that.
Exactly.
Okay.
And then lastly, the debtor must show that the sequestration will be to the advantage of creditors.
So it's not just about the debtor sort of getting a clean slate.
No, not at all.
It has to benefit the creditors as well.
Absolutely. It must be shown that creditors will get more out of a sequestration than out of any other arrangement.
Okay, so how do you actually figure out if there's enough free residue?
So the free residue essentially comprises the surplus value of encumbered assets over the amount of the encumbrances.
Okay.
And this includes assets that were bought on installment sale agreements, but where the market value is now more than the outstanding balance.
Oh, okay, so it can fluctuate?
Absolutely. And a case in point is Ex parte von Heerden, where the court confirmed this understanding of free residue.
Okay.
Another case that's relevant here is Mindel v. Share. This case also included assets that were bought through an installment sale agreement as part of the free residue.
Interesting.
And then lastly, there's the case of Ex parte Norte,
Okay.
where the court had to decide whether a right to payment that the debtor had ceded should form part of the free residue.
Okay.
And the court said no.
Oh, wow. Okay.
It was argued that an action to set aside that cession might not even succeed.
Right, so it's not guaranteed.
Exactly.
Okay, well, that's pretty complicated.
It is.
But, we're making our way through it. So let's talk about this advantage to creditors.
Okay.
How do you figure out if sequestration is actually going to benefit the creditors?
Right, so that's a crucial question. The court will need to look at what the likely outcome is for the creditors under sequestration compared to other scenarios.
Okay, and I guess the case law has developed some kind of guidelines for this? Okay, cool. Let's dive into that.
So some key cases that highlight this advantage to creditors idea. One is Epstein v. Epstein.
Okay.
And this case showed that just saying, oh, I'm going to have all these future earnings isn't enough.
Yeah.
You have to have concrete proof
Right.
that the creditors are going to actually get more from the sequestration.
Okay.
And then you have a case like Ex parte Harms that emphasizes that point.
Okay.
It says that the creditors must demonstrably receive a larger dividend.
Dividend, like a share of the assets.
Exactly, a larger share of the assets than they would through any other method.
Oh, okay. So it's like comparing investments,
Yeah.
Which one is going to give the best return?
Exactly. And in this case, the creditors are the investors.
Right.
So, sometimes debtors want to show that they're really serious about benefiting the creditors, so they'll offer to give up certain legal protections.
Like to sweeten the deal.
Exactly, like saying, hey, I'm willing to sacrifice some of my rights to make sure you guys get a better outcome.
Okay.
And Ex parte Anthony Ande on si soortgelijk and Soke dealt with this.
Okay.
And the court found that, you can renounce these protections.
Okay.
But it has to be done properly.
Right.
Ex parte Concado, for instance, made it clear that you have to explicitly renounce these rights.
So it can't just be like a casual, oh yeah, don't worry about that.
Yeah, exactly. It has to be very specific.
Okay.
And there are some protections that you just can't waive.
Right.
Ex parte Crow is, and that was later confirmed in Ex parte Van Dyke.
Okay.
Those cases said that certain protections, that are there to benefit the debtor, their families, the public at large, those just can't be waived.
So there's like a limit to how much you can bargain.
Absolutely.
Okay. So we've been talking about voluntary surrender, but what about when the creditors take the initiative?
Right. So that's called compulsory sequestration.
Okay.
And this is where the creditors go to court to force the debtor's estate into sequestration.
So it's like they've tried everything else, and now they're saying, okay, we need the court to step in.
Exactly.
Okay. But I'm sure there are requirements for that too, right?
Absolutely. You can't just show up and say, hey, this guy owes me money, sequestrate him.
Right.
There are certain requirements.
Okay.
So to apply for compulsory sequestration, you need to show that you're owed at least R100?
By one creditor.
By one single creditor, yes.
Okay.
Or R200 by two or more creditors jointly.
Okay, so there's like a minimum amount.
Yes, a minimum amount, and then the debt must be what we call liquidated.
Liquidated meaning like it's a certain amount?
Exactly. The amount must be fixed and determined.
Okay.
So like, you have a final invoice. Everyone agrees that that's the amount.
Right.
That would be a liquidated claim.
Okay.
Some examples of that would be in the Magat-Labamacau tribe and others, V. Van Sident case.
Okay.
The contract was canceled, and that created a liquidated claim.
Okay.
Or in the Premier Western Cape and others, V. Parker and Muhammad and others case.
Okay.
There, they had a delitual claim for a specific sum of money.
Okay.
Even determining the market value of shares, as was done in the Hassan and another V. Barange no case,
Right.
can create a liquidated claim.
Got it.
So it's about knowing exactly how much is owed.
Okay.
Now, on the other hand, if the amount of the debt is uncertain, we call that an unliquidated claim.
Okay.
So, for example, in Ex parte Bruce, the claim was for damages for a breach of a consent paper.
Okay.
And the court found that that was unliquidated because the amount was still uncertain.
So it's like an estimate.
Yeah, and it could change,
Right.
So that's important to keep in mind.
Okay.
So in addition to having that liquidated claim,
Yeah.
the creditor must also show that the debtor has committed an act of insolvency.
Act of insolvency. That sounds kind of scary.
Yeah, it does sound a bit scary.
Like, is it a crime?
No, it's not a criminal offense.
Okay.
But it's certain actions that indicate that the debtor is in serious financial trouble.
Okay.
For example, if a debtor leaves South Africa,
Okay.
or leaves their usual place of residence or business with the intention to avoid paying their creditors.
So they're running away.
Yeah, essentially they're running away.
Okay.
And a good case that illustrates this is J.M. Busha Investment Group, PDK Ltd v. Huxley. In this case, the respondent actually fled to Malawi.
Oh, wow.
To avoid the creditors.
So they really took it seriously.
They did.
Wow, okay.
Another act of insolvency is if the debtor disposes of their property in a way that would prejudice their creditors or prefer one creditor over another.
So like selling something for way less than it's worth.
Exactly, yeah. Or trying to move money around to prevent certain creditors from getting paid.
Okay.
And in De Villiers No v. Morsen Properties, Ltd., the court found that selling an asset significantly below market value while not paying debts that were due was an act of insolvency.
So they were trying to like hide assets, essentially.
Exactly. Okay. And then another act of insolvency is simply informing your creditors in writing that you can't pay your debts.
Okay, straightforward.
Straightforward, right?
Just like, sorry guys are broke.
Yeah, basically. But even this can have some interesting nuances.
Okay.
You know, in the case of Schabel & Co., Ltd v. Plank, the debtor's statement that he couldn't pay was not taken literally because the debtor clearly had assets.
Right.
So the context is always important.
Okay, so even that straightforward act can be interpreted in different ways.
Absolutely.
Okay, cool. No, we mentioned this earlier, friendly sequestration.
Right.
That sounds kind of odd. What is that?
So basically, the debtor arranges with one of their creditors
Okay.
to bring that application for compulsory sequestration. So it's like a staged thing.
So the debtor is actually in control in a way.
Exactly. They want to use the process for their own benefit.
Wow, that's interesting. Okay, so let's step back a bit.
Okay.
What happens to contracts when someone is declared insolvent?
So sequestration does affect the person's contracts, but it doesn't completely wipe them out.
Okay.
So the insolvent's capacity to contract becomes limited.
Meaning like they can't just go around making new deals?
Yeah, they can't just enter into any contract.
Okay.
They can still enter into contracts for necessities.
Right.
But anything beyond that requires the trustee's consent.
So the trustee gets to approve or disapprove?
Exactly. They're like the gatekeeper.
Right.
And any contract entered into without the trustee's consent is voidable.
Voidable meaning like it can be canceled.
Exactly.
Okay.
And there are cases that illustrate this. You know, Abu L. Carroll & Co. v. Rahal Motors, Ltd., McKay, DeFay, another. Both of those cases show that the trustee has this power to void contract.
Okay.
Now, the trustee also has to decide whether to uphold or repudiate existing contracts.
So they can choose to continue with the contract or cancel it.
Exactly. And that has implications for both the insolvent and the other party to the contract.
Right. So the trustee has a lot of power when it comes to contracts.
Absolutely.
Okay. What about the insolvent person themselves? Can they still work?
Yeah, they can still work.
Okay.
You know, sequestration doesn't mean they can't earn a living.
Right.
But there are rules
Okay.
about pursuing certain vocations.
So like if they were a financial advisor or something.
Yeah, they would need the trustee's consent.
To keep doing that job.
Exactly. Because, you know, it involves handling other people's money.
Right. It could be risky.
Yeah, and it's important to note that, you know, ignorance of this rule isn't a defense.
Right.
If you work without consent, there can be legal consequences.
Oh, wow. So you have to really make sure you know what you're doing.
Yeah, you need to get permission.
Okay, so we've talked about the restrictions on the insolvent person. What about the trustee? What do they do?
So the trustee is really the caretaker of the insolvent estate.
Okay.
And one of their main duties is to collect and realize the assets of the estate.
Realize meaning like turn them into cash.
Exactly. So they need to gather up all the assets, sell them off, and this includes not just obvious things like bank accounts and property, but also intangible assets like rights to payment, intellectual property.
Okay, so it's a pretty big job.
It is. It is.
Lots of responsibility.
Yeah, they step into the shoes of the insolvent person
Hey,
and take control of their financial affairs.
it's a lot of power.
It is a lot of power.
Okay, so they gather the assets, they turn them into cash, and then they distribute it to the creditors.
Exactly.
Okay, cool. But before the trustee can do that, the creditors have to prove their claims.
That's right.
They can't just show up and say, hey, I'm owed money.
No, they have to prove it.
Okay, how do they do that?
So the procedure for proving claims is laid out in Section 44 of the Act, and there are different procedures for liquidated and unliquidated claims.
Right, those terms you talked about earlier.
Exactly. Now there has been an amendment to Section 83.
Okay. That complicates things a bit.
How so?
So this amendment basically says that Section 44 doesn't apply to certain creditors who are realizing security based on master agreements.
Master agreements, what are those?
So these are complex financial contracts that are often used in derivatives trading.
Okay, so this is like a very specific type of situation.
Yeah, it's quite specific.
Okay.
And so because of this amendment, which was introduced by the Financial Matters Amendment Act of 2019 and the Financial Sector Laws Amendment Act of 2021, those secured claims are now dealt with under a different section.
Okay, so the rules are different for them.
Exactly.
Okay, so it's like a whole separate category.
It's a whole separate category.
Okay, let's talk about set-off.
Okay.
Sounds like canceling out debts.
Yeah, so basically it's a legal mechanism
that
allows mutual debts to be canceled out.
So like if I owe you money and you owe me money.
Exactly. We can just set off those debts against each other.
Okay.
But it can get complicated in insolvency. Right, because what if one person owes a lot more than the other?
Exactly, and that's why Section 46 of the Act gives the trustee the power to disregard a set-off
Okay.
in certain
So
circumstances.
they can say, no, we're not going to do that?
Yeah, if it would be unfair to the other creditors.
So it's like a protection against people trying to manipulate the system.
Exactly.
Okay. So what happens to the insolvent person after everything is settled?
So they can apply for rehabilitation.
Rehabilitation meaning like they're no longer considered insolvent.
Exactly, yeah. It allows them to regain their financial freedom.
So it's like a fresh start.
Yeah, it's a fresh start.
Okay. But it's not automatic, right?
No, it's not automatic. They have to apply to the court.
Okay. And I'm sure there are requirements.
There are, yeah, and it can take some time.
Okay.
But it's a really important part of the process.
Yeah, it gives people a chance to rebuild their lives.
Exactly.
Okay, cool. Let's talk about cross-border insolvency.
Okay.
Because, the world is so interconnected these days.
It is. It is.
What happens when these insolvency cases involve multiple countries?
Well, that's when things get really complicated.
Yeah, I can imagine.
You're dealing with different legal systems, different procedures.
Different languages even?
Different languages, yeah. It's a whole other ballgame.
Okay.
And one of the biggest challenges is figuring out which country's laws apply.
Right, because, who gets to decide?
Exactly. And how do you coordinate proceedings that might be happening at the same time?
Oh, wow. Yeah, that's a mess.
In different countries.
Yeah.
Yeah, it's a big mess. And South Africa actually hasn't ratified the UNCETRAL model law on cross-border insolvency.
What's that?
So it's this model law
Okay.
that provides a framework for international cooperation.
Right.
But because South Africa hasn't ratified it,
Yeah.
it creates a lot of uncertainty.
Okay, so it's like we're missing a piece of the puzzle.
Exactly.
Right.
And it makes it very difficult for foreign representatives.
Like trustees or liquidators from other countries.
Exactly,
Got it.
to recover assets in South Africa.
So if someone runs off to South Africa with a bunch of money,
Yeah.
their creditors might not be able to get it back.
It's very tricky.
Oh, wow, that's tough.
It is. It is.
Okay, well, you mentioned that we have a Cross-Border Insolvency Act.
Yes, we do.
But it's not in force yet?
Not yet. Okay.
What is that act supposed to do?
So that act is going to address a lot of these challenges.
Oh.
It's going to promote cooperation between courts.
Okay.
And make it easier to recognize foreign insolvency proceedings.
So it's like a step in the right direction.
Definitely a step in the right direction.
Okay, well, that's good to know. So speaking of taking steps in the right direction, what about business rescue?
Right. So business rescue.
Is that like a way for companies to avoid going bankrupt?
Yeah, it's a way to rehabilitate financially distressed companies.
Okay.
And hopefully avoid them going into liquidation.
So it's like a second chance.
Exactly.
Okay, but I'm sure there are requirements for that too.
Of course there are.
Okay, so what are they?
So the main requirement is that there must be a reasonable prospect of rescuing the company.
So it can't just be like a hopeless case.
No, it can't be a lost cause.
Right.
And the Van Niekerk v. Cereso 321 CCN, another case, really highlights this. They said, you can't just have some vague idea of how you're going to rescue the company.
It has to be like a proper plan.
Exactly. A proper plan with a realistic chance of success.
Okay, so there has to be some hope.
Yes, definitely.
Okay. And what happens to the creditors during business rescue?
So creditors have certain rights and protections during business rescue.
Okay.
They get to vote on the business rescue plan, for instance.
Okay.
And another important thing is that the moment a company files for business rescue, it suspends any liquidation proceedings.
So it's like hitting pause.
Exactly.
Okay.
And Richter v. Absa Bank Ltd. clarified that liquidation proceedings includes the entire process.
Okay.
Not just the initial application to court.
So it's a full stop.
A full stop, yeah.
Okay. And then what happens if business rescue fails or if it's not an option?
Then the company might have to go through winding up.
Winding up, that sounds pretty final.
It is pretty final.
So that's like the company is done.
Yeah, it's basically the end of the road for the company.
Okay.
So winding up is a formal process for dissolving a company and distributing its assets.
Okay.
And there are two main ways that a company can be wound up.
Okay.
Compulsory winding up
Okay.
and voluntary winding up.
So compulsory is like the court forces it.
Exactly.
Okay. And voluntary is like the company chooses to.
Exactly.
Okay, cool. What are the grounds for compulsory winding up?
So the most common ground is that the company is unable to pay its debts.
Okay, that makes sense.
But there are other grounds as well.
Okay.
If a company just doesn't start its business within a year
Okay.
of being incorporated,
Right.
or if they just completely suspend their business for a year,
Okay.
that can also be a ground.
So it's like they're not actually doing anything.
Yeah, they're not fulfilling their purpose as a company.
Okay.
And then there's a more general ground, which is that it's just and equitable.
Just an equitable, that's pretty broad.
It is broad, and it gives the courts a lot of discretion
Okay.
to look at the specific circumstances of the case.
Right.
So if there are disputes between shareholders or, if the company is just not managed properly, the court might decide that it's just inequitable to wind up the company.
Okay, so it's like a catch-all.
Exactly.
Okay.
The procedure for compulsory winding winding up is laid out in the Companies Act of 2008.
Okay.
And basically involves an application to the court.
All right, so it's a formal process.
Yes, a formal process.
Okay, let's talk about the liquidator.
Okay.
What do they do?
So the liquidator is basically the person who oversees the winding up of a company.
Okay, so they're the ones who, like, shut it all down.
Yeah, but it's more than just shutting it down. They have to make sure that the process is done properly.
Okay.
Their duties are very similar to the duties of a trustee.
Okay.
They have to collect and realize the assets of the company.
Okay.
Investigate the causes of insolvency.
So they're kind of like a detective, too?
Yeah, yeah.
Okay.
And then distribute the proceeds to the creditors.
Right.
So, in a case like Bernstein and the Bester and others, N&O, the court said that the purpose of interrogating directors during winding up isn't to play the blame game, but it's to gain an understanding of what happened to the happening.
So it's more about figuring out, like, what went wrong?
Exactly.
Okay.
And maybe preventing that from happening again.
Right. Learning from those mistakes.
Exactly.
Okay, cool. So the liquidator has to divide up the assets among the creditors. But are all creditors treated equally?
No, they're not.
Okay.
There's an order of preference.
Okay.
So first in line are the secured creditors.
Meaning like they have a claim to a specific asset.
Exactly.
Okay.
Then you have preferential creditors.
Preferential meaning like they get paid before others.
Exactly. So the law gives them preference for various reasons.
Okay.
And then you have the concurrent creditors.
So they're the ones who are left at the end.
Yeah, they get what's left over.
Okay.
After the secured and preferential creditors have been paid.
So it's like a hierarchy.
It is a hierarchy.
Okay. So let's talk about preferential creditors.
Okay.
What are some examples of that?
So for instance, employees who are owed wages.
Okay.
They're preferential creditors.
Right, because they need that money to live.
Exactly.
Okay.
And then also any taxes that are owed to SARS.
So the government gets priority too.
The government always gets its share.
Okay.
So those are just some examples.
Okay, cool. Now let's go back to cross-border insolvency.
All right.
What happens when you're dealing with an external company that's like a branch of a foreign company operating in South Africa?
Right.
What happens if they're in trouble?
So that gets really tricky because you might have the foreign parent company also going through insolvency proceedings.
So it's like double trouble?
Yeah, double trouble.
Okay.
And the question then is, can the South African branch be rescued?
Right.
Or does it just sink along with the parent company?
Okay.
And unfortunately, South African law isn't very clear on this.
So there's like no answer.
There's no easy answer.
Okay.
There's a lot of debate about whether business rescue or compromises can even apply to external companies.
Oh, wow.
So it's really a challenging area.
Okay. I'm sure we'll figure it out eventually.
Hopefully.
Okay. Let's talk about compromises.
Okay.
So that's like a company making a deal with its creditors.
Yeah, exactly. It's a way to restructure debt
Okay.
and avoid liquidation.
So it's like a negotiation.
It is a negotiation.
Okay.
And it has to be done in accordance with the Companies Act.
Okay.
So there are formal procedures.
Right.
And a statutory compromise actually differs from a common law or contractual composition.
How so?
So a common law composition requires the agreement of all creditors.
Oh, wow.
Whereas a statutory compromise, which is governed by Section 155 of the Companies Act, only requires the agreement of a majority.
Oh, so it's a bit more flexible.
It is a bit more flexible.
Okay.
And it can include a variety of terms.
Okay.
So you can renegotiate payment terms. You can reduce the amount of debt.
Okay.
You can even convert debt into equity.
Wow, so it's pretty powerful.
It is a powerful tool.
Okay.
Now, cases like Commissioner South African Revenue Services v. Logical Consulting, PIPI Ltd. And others.
Okay.
The Commissioner of the South African Revenue Services v. Cross Atlantic Properties, Ltd.
Okay.
Make it clear that a statutory compromise is only for situations where a simple agreement between the debtor and creditor wouldn't suffice.
So it's for more complex situations.
Exactly.
Okay.
And importantly, even tax debts can be included in the compromise.
Oh, wow.
So you could even make a deal with SARS.
Okay, so it's like a way to bring everyone to the table.
Exactly.
Okay, cool. So let's talk about foreign representatives again.
Okay.
What happens if they want to recover assets that are in South Africa?
So they would need to approach the High Court in South Africa.
Okay.
And basically ask for recognition.
Of their authority.
Of their authority, exactly. And they would need to show that they've taken steps to notify local creditor.
Right, because those creditors might have a claim to those assets too.
Exactly. It's about transparency and making sure that everyone is informed. So it's not a simple process.
Okay, now imagine this. You have an external company in trouble.
Right.
But their foreign parent company is also going through insolvency proceedings in their home country.
Yeah.
What happens then?
So that's a real head-scratcher.
It's a mess.
Yeah, it's a mess. And, there's uncertainty about whether the South African branch can be rescued or whether it just has to go down with the ship.
Right.
And this is another area where the law is not very clear.
So we need to figure that out.
Yeah, we need more guidance.
Okay. Now let's talk about the discharge of debts.
Okay.
Specifically, debts that have like a foreign element to them.
Okay, so what happens when a debt is discharged?
Meaning like it's wiped clean.
Exactly. Under the insolvency laws of a foreign country.
Okay.
Is that discharge recognized in South Africa?
Okay, so that's the big question.
That's the big question.
Okay.
And the answer is basically yes.
Okay.
But there are two rules.
Okay.
So rule number one, if a debt is discharged under the insolvency laws of a country, whose law governs the contract, then that discharge is recognized as valid in South Africa.
So like if the contract was made under French law.
Exactly.
And a French court discharged the debt.
Yes.
South Africa would respect that.
South Africa would respect that. But there's an important caveat. The discharge must extinguish the debt itself, not just interfere with remedies or procedures.
So it'd have to be like a complete discharge.
Exactly, a complete discharge. And that was confirmed in African Banking Corporation v. Owen. So that's rule number one. Rule number two is a bit more complicated.
All right, hit me with it.
So if a debt is discharged under the law of a country, other than the country where the debt arose, then that discharge doesn't necessarily relieve the debtor in other countries.
Wait, so how can a debt be discharged in one country but still exist in another?
Yeah, that's the tricky part. But different countries have different laws. So there can be conflict. And Ferguson v. Stanton is a case in point. So in this case, the parties entered into a contract under English law. But the debtor was French. And he was declared bankrupt in France. Under French law. So the question was...
Does that finish bankruptcy?
Exactly.
Get rid of the English debt?
Exactly. And the court said no.
Oh, wow.
It doesn't. So the English debt still stood.
So even though he was bankrupt in France, he still owed the money under English law. Wow, that's wild.
It is. It is.
Okay, so this rule is pretty old, right?
It is. It's from 1884. But it's still relevant today.
It stood the test of time.
Exactly. And a recent UK case, RehOJSC International Bank of Azerbaijan, Bafshieva v. Sberbank of Russia and others, applied this rule. And it shows, even in today's globalized world, these conflicts can still arise.
So we really need, like, better international frameworks to deal with this?
Absolutely.
Now back to those external companies. We talked about the challenges of applying business rescue and compromises.
Yes.
But there's another layer of complexity.
Okay, tell me more.
What if an external company restructures in its home country? And that restructuring changes the terms of contracts that were originally governed by South African law.
African law?
So like what if those contracts were supposed to be performed in South Africa?
Exactly.
But now they've been changed by this foreign restructuring.
Yeah, it's a tricky situation.
So do those foreign decisions like automatically override everything?
So that's the question. And unfortunately, the answer isn't always clear-cut. South African law could definitely benefit from some more clarity in this area.
You would be helpful to have some specific rules.
Absolutely. But, because a lot of our legal principles stem from English law, we can look to the English courts for guidance.
So like what have they done?
So in the case of RehOJSC International Bank of Azerbaijan, the English court decided that a restructuring plan that was implemented under Azeri law didn't automatically apply to debts that were governed by English law.
Oh, interesting.
So, this kind of suggests that South African courts might follow a similar approach. They might say, hey, those original contracts were made under South African law. We're going to uphold those agreements.
So those agreements are still valid?
Exactly.
Cool. So it's really important to like think about these things that you're drafting contracts.
Absolutely, especially when you're dealing with international agreements.
You have to anticipate these potential conflicts.
Exactly. You need to know what you're getting into.
Now let's go back to external companies again.
All right.
So we've talked about the challenges of business review and compromises. But there's another big question. Can an external company even be wound up in South Africa?
So that's a really good question. And to be honest, the law isn't entirely clear on this point.
Oh, no.
There's some debate about whether the Companies Act actually allows for the winding up of an external company. You see some argue that the act really focuses on South African companies, not branches of foreign companies. So it's all about interpretation.
So what did the lawmakers actually intend?
Exactly.
So this lack of clarity could be a problem?
It definitely is a problem.
For creditors?
For creditors and other stakeholders who are trying to, get their money back.
But is there any case law on this?
So despite the lack of clarity, There is a case, Sackstein No v. Proudfoot, SA, Ltd.,
Okay.
which suggests that an external company can be wound up in South Africa,
Oh, interesting.
even if its foreign parent company is insolvent.
So there is some precedent.
There is some precedent.
Yes. Wow, that's pretty fascinating. So clearly this is an area where we need more guidance.
Absolutely. We need clearer legislation.
Yeah, maybe even some reform.
Yeah, to really address these challenges posed by external companies.
Okay. Well, that's a lot to think about.
It is. It is.
But before we wrap up, I want to touch on this Cross-Border Insolvency Act again.
Right.
It's not in force yet.
Yet.
But it seems like it has the potential to really change things.
It does. It does.
So what are its main goals?
So the main goal of the Act is to promote cooperation between courts.
Okay.
So cooperation between South African courts and foreign courts.
Okay.
When it comes to cross-border insolvency cases.
So it's about making the process smoother.
Exactly. Making it smoother, more predictable.
Yeah, because right now it's kind of a mess.
It is a mess, and the Act is based on, internationally accepted principles of cooperation.
Okay.
And it gives guidance on, recognizing foreign proceedings.
Yeah.
Giving relief to foreign representatives.
Okay.
Coordinating those parallel proceedings
Right.
that we talked about earlier.
Yeah.
So it's a really comprehensive framework.
It sounds like
And
that.
once it's implemented,
Yeah.
it will really help South Africa deal with these cross-border issues.
Okay. Well, that's really exciting.
It is exciting.
I mean, it's great that we're taking steps to kind of modernize our laws.
Yeah, insolvency is a global issue now.
Yeah, it's not just a local thing anymore.
It's not just a local thing.
Okay, well, this has been a really fascinating deep dive.
It has.
Into the world of South African insolvency law.
Mm-hmm.
We've covered so much.
We have.
From the history to the current challenges to what the future holds.
Yeah, it's a really dynamic area of law.
It is. It is.
Always changing.
And it's definitely more complex than I think people realize.
Absolutely.
But hopefully we've made it a little bit more understandable.
I hope so.
And maybe even a little bit interesting.
Yeah, me too.
So, as always, we encourage you to keep learning and exploring.
Yeah, there's so much more to discover.
Join us next time for another deep dive into a different topic.
I can't wait.
Until then, stay curious.